So I hope you're all, excuse me, maybe your attention, please. So first, I would like to thank all of our panelists and all of you in the audience. I thought this was a terrific conference, great, robust exchange of views on very important topics. It's what the ITPF is all about. And I think there was some heat, there is some light, and this discussion will be ongoing. But thank you, Atai and Lily, and thank you, Peter Merrill and Jim Hines, for making this all happen. So it's my pleasure to introduce our luncheon speaker, and we're going to do a Q&A format. The questioner is going to be Pat Brown, who you probably already heard enough from today, but Pat's the co-head of the National Office of Price Waterhouse. He spent time in the private sector at GE and at a big law firm, time in the Treasury. He's really an international expert. And actually, when I looked at his bio, I didn't realize he was an engineer. Which I think probably distinguishes him from most people in this room, and explains why he's such a great tax lawyer. Our luncheon speaker is Ken Kies, who again, I think needs no introduction to anybody in this room. Ken is the Assistant Secretary of the Treasury for Tax Policy. He's also the Chief Counsel of the IRS, I think, at the moment. He tells me he doesn't get 2 checks, but I'm not sure. He does do 2 jobs. He is a long distinguished career in public service. He was Chief Republican Tax Counsel of the Ways and Means Committee, Chief of Staff of the Joint Committee, worked in the private sector first, I think it was the managing tax partner at Baker Hostetler, one of the great law firms in the country, a co-head, I think, of the Washington practice of Price Waterhouse for a while. He has that in common with Pat, and then ran his own shop for a while, the Federal Policy Group. He's a veteran. We're lucky to have somebody who understands the process and the law in such an important job. Ken has agreed to take questions from the audience. So that's it. Pat, over to you.
All right, very good. Thank you, John. And more importantly, thank you, Ken. It's great to have you here with us. Ken, I'm just going to jump right in. As you, I'm sure, are aware, the title of this conference is Tax Sovereignty in 2026 and Beyond. And as I mentioned on the earlier panel that I was moderating, the idea of doing a conference on tax sovereignty didn't just come out of nowhere. I want to take you back to the start of this administration. In fact, literally day one, President Trump issued an executive order, a defense of U.S. tax sovereignty, I would describe it as, noting that the OECD's Pillar 2 project limits our nation's, this is a quote, limits our nation's ability to enact tax policies that serve the interests of American businesses and workers. So that kicked off a process, of course, at the OECD and the OECD G20 inclusive framework. Just about a year later, just a little under a year later, we got the side-by-side package. And obviously, once the side-by-side package has been adopted by all relevant countries, it effectively turns off the Pillar 2 UTPR and the Pillar 2 IIR for U.S. headquartered companies. So maybe to kind of softball to get things started, can you talk to us a little bit about how we got here? And I guess I would say importantly, as we think about where we are literally today on the side-by-side package, we got a lot of folks who've agreed to it, a lot of countries who've agreed to it, but frankly, not a lot who've actually implemented it yet. So can you talk maybe about where we are right now and how we got here?
Sure. So first, let me tell you how lucky you are that I'm here today. And by which I mean that at 9 o'clock, I was in my office this morning and the Secret Service came running in and they said, everybody out of your offices, go to the, this is interesting. I'm in the front of the building. They said, go to the middle of the building. So I'm thinking, well, okay, if there's something going to blow up, or they only think it's going to take the front half of the building off, or what? And so we were all back there for half an hour, and nobody told us what was going on. People were running back and forth. And then they finally came and said, "Oh, okay, all clear." And we said, "Well, what was it?" They said, "Well, one of the dogs was having a problem." What do you mean the dog was having a problem? What about our problems? So anyway, that's why you're lucky I'm here. So let me start by addressing the question. And I actually looked at some of the slides before I came here. I think Lillian and Ralph did a great presentation. Where's Lillian? On tax sovereignty. Started with the 1789 Constitutional Convention. I assume John gave you some like personal experiences of what that was like. So, you know, it's helpful to have people with experience. But to answer your question, Pat, look, it's no secret how we got here. It started with like a really bad idea called Pillar 2. And then it led to the election of a president with an administration who didn't think Pillar 2 was such a great idea, who partnered up with the chairman of the Ways and Means Committee and the chairman of the Finance Committee and a number of other Republican members who felt, and I don't want to make this personal, I think there are Democrat members who are concerned about it as well. And that's what led to the day one notice, which led to the G7 agreement. I think Section 899 may have helped clarify their thinking. That is the G7 in terms of coming to that agreement. But then there was skepticism as to whether the inclusive framework was going to agree to it. And we got into December and we kind of had one deadline and we missed that deadline. Then we had another deadline. Anybody here from Estonia? What the hell was Estonia holding up the whole thing for? I mean, they must have been having a bad day. But on January 5th, I think we finally reached agreement. And you've asked a question, which is a question that has been on the minds of the two chairmen and the Treasury Secretary since then, which is, will there be faithful implementation by the countries in the inclusive framework? We feel very good about that. Okay. We think we're making progress. We understand different countries have different timetables under which their legislative bodies move. So I wouldn't say there's any nervousness that we're not going to get implementation. Okay. So, I mean, that's basically the story.
Okay. Thanks, Ken.
Well, I will say one other thing. Rebecca Birch, who's my Deputy Assistant Secretary for International, has been very effective at getting people to agree. And it's mainly because, this is not on the record for you with the press here. I'm serious. Rebecca scares the other people at the OECD, okay? And I've heard them murmuring, if we don't agree to what Rebecca wants, something bad could happen to us. So she has been very effective at helping people clarify their thinking. And so that none of that happened by accident. Right. It was a very thorough, concerted effort, which not only involved Rebecca, but it involved our economists who spent an enormous amount of time doing economic analysis to persuade some of the members of the inclusive framework who may have been concerned that our tax regime was not robust enough to be an adequate substitute for Pillar 2. I think we were successful in convincing them of that. No, because we have the data.
Yeah, right.
I mean, so it was a team effort.
Yep. Okay, thanks, Ken. So you mentioned the word nervousness and not being nervous about, where we are. I think one of the sources of anxiety for a lot of folks in the business community, beyond crossing their fingers and hoping that this all gets implemented, is the reference in the side-by-side package to what they refer to as a stock take, which the package itself says that will happen by 2029. It seems pretty clear now that's going to happen in 2029. And as you probably understand, certainly some folks in the business community are like, well, is this going to be, an attempt to recut the deal or reopen the discussions that led to the side-by-side agreement?
So I guess I have a couple of observations about that. Believe it or not, in between dodging the bomb sniffing dogs this morning, I actually took a look at that section. It's 3 paragraphs, many words, many words. Let me translate what those many words say. Along about sometime in 2029, we're going to take a look, see how things are going. But we won't do anything that isn't a consensus decision.
Right.
End of discussion.
Okay.
So should you be nervous? Not really sure. You should be. Let me tell you what my focus is. It's the regs I have to get out by June 30. That's my focus right now. And so yes, there will be a stock take.
Right.
Does anybody know where the term stock take comes from? Anybody?
No, I don't.
I never even heard of that term, but somebody came up with that. That's one of the things the OECD is good at. They come up with new terms. You know, the inclusive framework. It's like we're all inclusive now.
Yes.
But so my bottom line on the stock take is nobody should get too like unraveled about it.
Yes.
And there will be discussion, but it's very clear nothing will happen that isn't a consensus, and we will be part of that discussion.
Yep.
So
I love, you talked about a lot of words in the 3 paragraphs with respect to the stock take. If you think that's a lot of words, let me commend to you the OECD's Pillar 2 rules and all of the accompanying commentary and guidance that has followed the release of those rules. It is, I will say, an extremely complicated system, very detailed. The compliance that burden that a lot of companies are facing is very significant, notwithstanding that many of the companies, I'll even go a little bit further, most of the companies that I speak to expect very little incremental tax under Pillar 2, and yet there's a very significant compliance burden associated with it. That's all backdrop, Ken, to the fact that we continue to hear from the OECD that more guidance is coming. They're going to continue to push out additional rules with respect to some issues. And among the things that they've talked about, and again, this is back to the paranoia or concern about the stability of the side-by-side package, is this idea of additional integrity measures to prevent something somehow undermining the agreed premises of the side-by-side package. One of the things that I'm struck by is comparing that approach to President Trump's deregulatory agenda and the executive order that he issued suggesting that for each new regulation, 10 regulations should be removed. Has that concept been talked about with the OECD? How far do you think that would get with the OECD?
Look, I don't want to have a fight with the OECD, but they seem to like rules. And yes, there is discussion about integrity, but there's also discussion about simplification.
Right.
We are, just to be clear, we are continuing to be as engaged as ever with the OECD discussion. We actually want to be helpful in terms of simplification ideas. But we've got our antenna up on the integrity matter.
Okay.
But again, not to be too repetitive, but nothing's going to happen that isn't a consensus decision. So we'll be very focused on whether, quote, integrity really means something else. I guess not something we're completely exercised about.
So I'm going to throw a little love the OECD's way and note that, over the course of its, frankly, 70-year history, I don't know exactly, but, around that time, around that amount of time.
John would know. No.
Exactly. Seems like yesterday, doesn't it, John?
Yeah, that's right.
The OECD has been, I would say, well known for some really outstanding work in the tax area. The OECD Model Tax Treaty, really stands out as, an exceptionally thoughtful product that has obviously, been ambulatory over time, been developed and had some changes as they've confronted new issues. I would also point to the transfer pricing guidelines, another document. I would say both of these things represent, at some level, the OECD doing what, for most of us who've been practicing tax law, we sort of had always expected the OECD would do, which is be sort of a standard setter, develop concepts and principles. I'll refer to a term that Barbara Angus used on an earlier panel, develop principles that then countries would seek to apply in their rules. The pillars represent a pretty, significant step away from that sort of principles standard setting type approach. How is the current Treasury Department thinking about the role of the OECD going forward?
Well, okay, so this isn't going to be a news flash. I mean, obviously, we thought the OECD getting off on Pillar 1 and 2 was not what their core responsibility or function that they've served over many decades. We think the focus on transfer pricing, model tax treaties is exactly where they should be focused. Right. We are very supportive of that. We're significant funders of the OECD, right. Although there was a lot of examination of whether that should continue when Pillars 1 and 2 were right. Out there in the debate, if you will. But we feel great about what is the OECD's core competency, and that fully support that as where they should be focused.
Yep. Okay. I'm going to now use another term that's been bandied around about a lot recently: constructive dialogue. The discussions of Pillar 1, and you can give your thoughts on Pillar 1 as well, but the discussion of Pillar 1 has morphed into, essentially, as I understand it, but obviously correct me, Ken, to the extent I don't get this right, a willingness on the part of this Treasury Department to engage in a constructive dialogue with respect to the taxation of the digital economy, which of course was, we had used that term 2 years ago, we would have all understood that, broadly speaking, to be the thing that led to the pillars, particularly Pillar 1. So now we're sort of re-engaging or restarting this kind of constructive dialogue at the OECD to talk about how we're going to take that whole concept forward. So I'd love it if you could talk a little bit about that. And at the same time, I would note, obviously, the U.S. is actively engaged in those discussions at the OECD. At the same time, there's another set of discussions going on at the UN with respect to taxation of high-value cross-border activities, I'll call it. And that is moving forward without U.S. participation. So maybe talk about both of those things, Ken, if you could.
Okay, well, let me start with Pillar 1, and just for the press, what I'm about to say is not news, because I've already said it multiple times. Nobody should be confused. Pillar 1 is dead. The United States is engaged in a constructive dialogue on digital service taxes, but that should in no way be interpreted that we are picking up where Pillar 1 left off. That is not what we're doing. Okay. We are being a good participant in the OECD. We're having a constructive dialogue. We are operating under no deadline for the completion of that, notwithstanding what some of our friends in Europe have suggested that we should be operating under. Yeah, that's what it is. It's a constructive dialogue. We happen to think that perhaps part of what led to Pillar 1 was an absence of some thorough examination of what was really either wrong or not wrong with existing tax systems as they relate to digital service tax or digital service activity. Right. So yeah, we're engaged in a constructive dialogue, but nobody should be in any way confused into thinking that somehow means we're reviving the discussion about Pillar 1, because that's not what we're doing. In terms of your question about the UN, yes, we're not participating. We didn't view it as a useful exercise. As you know, the UN can operate and approve things with 51% of the votes of the countries involved. The OECD, 100% different, requires consensus. So we actually think any discussion about significant international tax issues, that belongs in the OECD. Okay. It's where their core competence is. So no, we're not participating in the UN, and we don't think we're missing out on anything by not participating.
Okay. Thanks, Ken. You talked just a second ago about DSTs. As I think back, couple of things that notable about DSTs. The first is in a town where there seems to be very little bipartisan agreement about just about anything, DSTs certainly stand out in the tax area as an area where both parties have been very vocal. Senator Wyden, I think, has been every bit as strong in his opposition to them as some of his Republican counterparts. I would also note, though, that when Section 899 was first brought forward, DSTs were within the ambit of Section 899 as something that would face, I'll use the term retaliation under Section 899. When the G7 agreement was announced and 899 was pulled from the bill, of course, the G7 agreement focused very much on Pillar 2, not on DSTs. It then seemed like DST sort of migrated a bit over to the trade space within this administration and some of the bilateral trade agreements that were negotiated. So are DSTs a tax issue? Are they a trade issue? Are they both? How's the administration think about them?
Well, I think, and this is probably obvious, they think about it as both a tax and trade issue. We work very closely with our colleagues at USTR on topics like this. As you know, the administration's been very clear, and the USTR about the possibility of 302 actions if people pursue DSTs. The administration's been very outspoken that it does not, that thinks digital service taxes are a very bad idea.
Yeah.
Yeah, and I think that is largely a consensus view. We support, again, our USTR colleagues if it's a trade-focused initiative, but we also provide technical analysis from the tax perspective as well. So I'd say we're in partnership with our colleagues there.
Okay. I'm going to move us away from the OECD and the UN for a bit and talk about something you also mentioned just a few minutes ago, Ken, which is regulations you're trying to get out. Maybe talk a little bit about Treasury's regulatory priorities. I'd love it if you could talk about it both from the perspective of the OB3 regs that you guys are working on, as well as, again, referring back to President Trump's deregulatory agenda, which is something that this Treasury has certainly seemed to embrace. So your thoughts around those?
So literally since before the bill was signed a year ago, July 4th, the Treasury and the IRS Chief Counsel's Office had a very comprehensive game plan for implementing OB3 in terms of the regulatory initiatives that needed to be accomplished,
right,
whether it was regs, notices, amendment of returns, creating new forms, for example, with respect, Form 1A, Form 4547. Anybody not know what Form 4547 is? Okay, it's the Trump account. Does anybody know why it's called Form 4547? If you don't understand, you really should leave. But
we should make it clear for some of our non-U.S. friends in the room. President Trump was the 45th administration, and now the 47th administration. So,
thanks for that clarification.
Right, yeah.
So again, but even before the bill was signed, a comprehensive game plan, timeline, and we're following that.
Yep.
So not surprised. It's not a surprise that in the early stages, which I would describe as from July 4th to the present,
right,
but in particular through the end of last year, the focus was very much on provisions that were effective in 2025.
Yeah.
And now we're pivoting a little bit to focus on those provisions that take effect January 1 of 2027.
Right.
So scholarship granting organizations would be a good example. We actually had a program yesterday with the First Lady who came over to the cash room and did a program with Secretary Besant. She's she has been very focused really for many years on foster children. And the focus of yesterday's program was to highlight all the steps that the Treasury is taking and IRS through the implementation of Trump accounts to make them available to foster children. And that largely involves focusing on the role of state agencies that essentially are responsible for foster children, because you need some guardian who's making the election to create a Trump account for a foster child. So that's a good example of a regulatory activity that's ongoing right now. We're aiming for July 4th, when the first $1,000 will go into Trump accounts for any child that was born on or after January 1, 2025 through the end of 2028. I already have one in the bank. I've got a 1-year-old grandchild. I turned one about 3 weeks ago, weighs in at, I'm not making this up, 30 pounds.
Wow.
And he doesn't walk yet, but my daughter said he can stand up and open doors, and he's freakishly strong. Okay. So
Maybe a future Ohio State linebacker.
I think no doubt. So I already got one. I have one in the bank, and my older daughter is due, I'm not making this up, July 4th. On July 4th, on the 250th anniversary. And I've told other crowds that there was a serious drafting error with respect to the Trump account provisions, which I'm hoping to fix very soon. It should have provided that if your child is born on July 4th, on the 250th anniversary, you don't get 1,000, you get 10,000. And yesterday,
It's a lot of pressure on your daughter, you know. I mean, that's.
I have two comments about that. But yesterday at the program, Secretary Besson, in explaining the program, mistakenly said, and will contribute 10,000 for each child born, and everybody went, and then he went 1,000, 1,000. I thought he was surfacing the technical correction. I was very disappointed. But yeah, the pressure on my daughter is intense because, for a different reason, she lives on Capitol Hill, which she lives, I don't know which direction I'm pointing, but she lives near the Eastern Market. Her hospital is Sibley. Now, can you imagine having to get from Capitol Hill to Sibley on July 4th?
Right.
My wife has instructed her that if the baby hasn't been born by July 3rd, she's coming to our house in McLean,
Right.
because there's no way she'd be able to get across town.
Yeah.
So that's the real pressure.
Yeah,
But our regulatory agenda involves continuing to implement OB3, but also, because we can walk and chew gum at the same time, we have other regulatory initiatives.
Right.
A very prominent one is the CAMT issue.
Yep.
As you know, we've put out 5 notices on CAMT in the last 12, since the beginning of last year. Basically, we think right sizing the applicability of those provisions to make it consistent with what was the legislative intent. We are now drafting regulations to implement those 5 notices. Those draft regs will probably be issued somewhere in the neighborhood of February of 2027,
Okay.
but there's an enormous amount of work going
Yep.
into that. And then we also have compliance initiatives that also occupy a lot of IRS chief counsel time, but also people at the Office of Tax Policy as well.
Yep.
And one prominent one is the settlement initiative we put out on conservation easements,
Okay.
just as an example. So yeah, we've got a very busy agenda, even though we got through the first filing season.
Yep. So I'm going to warn the room here. I've got one more question for Ken, but then want to open it up to the group. Ken, you mentioned Capitol Hill, which of course we are a mere stone's throw from the Capitol. I'm not going to ask you whether we're going to have another reconciliation bill, but I do want to ask you if you could, as John alluded to, you've been at this game a while, meaning in the tax policy space. We had in the first Trump administration, the Tax Cuts and Jobs Act. We had the One Big Beautiful Bill. Obviously last year, coming up on the 1-year anniversary of that. When you think about, I'll use the term unfinished business, particularly this is the International Tax Policy Forum, as you know. When you sort of think about where our international tax rules are now relative to where you'd like them to be or where the administration would like them to be, are there items that you feel like are unfinished business or that the administration would like to see more progress made in this space? Or do you feel like, we kind of got things where we want them?
Okay, so let me give you a couple of thoughts about that. So on the issue of whether there will be another tax bill, well,
I told you I wasn't going to ask.
well, it's okay. I can give you one answer. Jason Smith was at the event with the First Lady yesterday, and he walked out there. He said hi. I said, "Hey, is there going to be another reconciliation bill?" I can't tell you what he said. So how's that for news?
Right.
So
Yeah, do you mean you can't tell us because it was unprintable, or you can't tell us because it was confidential?
because I'm not
Both?
telling you. Okay.
Got it.
In terms of whether the administration has other legislative initiatives that it would like to see Congress take up, there certainly are things that we think about.
Yeah.
But it probably, you probably should get some inclination of how strong our thinking is on that, in that we did not include tax proposals in the budget.
Right.
As everybody knows what the Green Book is.
Right.
We didn't do a Green Book. And part of the thinking was we're going to stand pat on the bill that the president signed last July 4th. I mean, that was a big piece of legislation, and our focus is on implementing that. So that doesn't mean that we won't be looking at things. As you know, Ways and Means had a hearing this week on crypto, clearly a fast-moving topic. We've, not surprisingly, provided technical advice, as we did throughout the OB3 process. And there are other issues. Well, one of the things everybody in this room is familiar with is the phenomenon that things pop up as you move through a year that you had no idea was going to require legislative action, including in the tax area. Right. So we're also, prepared for things like that might arise. But I would say right now our focus from a tax policy perspective is clearly on continuing to implement OB3, and then looking at some of these other issues that we know are current.
Yep, got it. Okay. So thanks, Ken, for that. As I mentioned, I'm now going to open it up to anybody in the room who has questions for Ken. So don't be shy.
Yeah.
Natalia, please. Yeah.
Yeah, thanks. You were mentioning DSTs and how you were looking at those with the trade people. Are you also looking at significant economic presence provisions?
I can't really tell you. I'm guessing the whole thing of permanent establishment and whether or not that's a concept that should be revisited in light of the whole DST debate, somewhat involves that topic, but it's not something that's a very prominent priority right now. Yep.
By the way, I introduced Natalia sort of when she asked the question, but please just identify yourself when you, so Ken knows who he's talking to.
Yeah, I'm Jim Nuns again, still. Well, so can I have a question for you and an offer? So the question is, are you planning to watch from the 5th floor the Treasury building on the White House side, the WWF, rather than pay to get in? Just quick, I had that office and used to watch the helicopter land and stuff. That was a long time ago.
Let me answer that question. So it's hard to see much of anything because there's so many cranes up. But the cage has been erected for the fight. They've been testing the music and the lights over the last couple of days. And we've been sort of under assault for months now because of the construction going on. And I'll tell you, since you know about the offices, I'll tell you about one phenomenon that was a little unsettling for me. When they were taking down the east wing, there was a lot of shaking of the building.
Yes.
And you know how under your desk you have those big plastic things. Well, I have one that's about this thick, and my desk is on this side of the room. And over the course of every 3 days, the plastic thing would move all the way across the room to the other side of the room. And then they'd have to send these big burly guys in to pull it back over the other side. And then it would start to move back. So, yeah, when I go to work, I feel like I ought to have a hard hat on. So,
Well, yeah, I can explain. There are steel beams. The Treasury, it used to be that anytime a truck ran on 15th Street, and if you were in 4121, the floor would shake. So that was just there. But I think you have enough pull that you could get the cranes out of the way for one. So my offer is, all this strenuous OECD work in Paris, I would be more than happy for just, travel per diem and a small fee to fill in at any time.
okay, we'll take it under advisement.
Should I wait by my email? or-
Probably not. But it's, you're a patriot for making that offer. That's all I can say. It kind of reminds me when I was at the Joint Committee, and when you're at the Joint Committee, members of Congress think that in your drawer you hide these ways to raise revenue.
Well, in fairness, Mark Prater did, we know,
Well,
but he
well,
wasn't at joint
yeah,
committee.
Okay, but, well, and by the way, if you haven't been in the Treasury office outside my building, Mark Prater's portrait is there. And if you think I'm joking, it's some guy who's long dead, Mark, sorry, but it is an uncanny likeness for Mark Prater, okay? But I would, so I got this letter one time from a handwritten note from Newt Gingrich. We need 1.2 billion to pay for Locke Faircloth's educational provision. And I'm sitting there, I'm thinking, what does he think? I just have money all over the place here. So I thought, I've got a solution. I wrote him a personal check for $1.2 billion. And I sent him a letter. It said, "Dear Speaker, I've got your letter requesting a way to cover the costs. Please see the enclosed." I get a letter back from him. It says, "I accept on behalf of a grateful nation." So I accept your offer on behalf of a grateful nation. Okay.
Excellent. That was a great exchange. Other questions for Ken?
It didn't have much to do with tax policy.
Yes, but yes, John, please. You're getting a mic.
Talking about international tax issues, and in particular focused on the mobility of intangible assets. We're heading into what may be the next revolution, technological revolution with AI. And none of us really understands, at least I don't understand it fully yet, but I do believe it's going to create huge productivity gains, huge changes, maybe a lot of unemployment, which is now being referred to as dislocation. As the Treasury administration, are you thinking about how to tax it in a global integrated economy, and what you might do if there's large unemployment and the consequent fall off of revenue from not having a lot of labor income?
So I know this is an issue that's getting a lot of attention. And there's a lot of speculation. I'm sure we all read some of the same stuff. Some people saying it's going to have this dramatic negative impact on labor. Other people saying that's what that's what they've said about technology advances, whatever form, for decades, and it's always actually had the opposite effect. So we at Treasury, people in the private sector, other parts of the administration, yeah, we're all watching that issue. I don't think anybody has like the magic answer of which way it's going to turn out. I would say on AI, the bigger focus of both Treasury and the IRS is on harnessing AI and figuring out how we can use it to better do what we do. And it's a bigger issue at the IRS than it is, frankly, at Treasury. And I would say people have asked are you preparing for the future of AI? And the answer is no, we're preparing for the present because it's here. And just as one example, in the most recently completed filing season, the IRS had more hits to its systems that provide artificial intelligence, whether it's check for my refund, irs.gov, you name it. They had 200 million more visits to those sites than a year ago. So a year ago, it was about 300 million. This year was over 500 million. That's just how dramatic the growth is. And as a result, one of the consequences is the IRS had less phone calls. And the reason, and both the CEO, Frank Bizignano, and the secretary have both made this point with pretty much the same words. They have said that what the IRS is doing is providing service to its constituents, taxpayers, in the same way in which they get service from other people that they interact with, which is 24/7 online. So I would say the bigger focus, John, yeah, tax issues. Yeah, there are tax issues. There's digital economy or Bitcoin, staking. We just won a case on staking. But the bigger focus is on utilizing AI. And going back to my evacuation this morning, I mean, I know people know I'm old. So I actually had a meeting scheduled with our AI geniuses. You know, some guy walked into my office yesterday and said, I'm the guy that's in charge of teaching you AI. Of course, you know, sandals, you know, no tie. So perfect. You're the guy. I can tell you actually know this stuff. And one of the things I've heard about law firms, which illustrates this point, many law firms are educating the law firm about AI by assigning first-year associates as mentors to the partners. Okay, think about that. That says a whole lot. And I was supposed to have a 2-hour session this morning until I got evacuated out of my office. But I will be rescheduling that because we all need to understand this stuff and its capabilities. Although in the legal profession, it was reported just in the last day or so, another instance in a federal court. It was either a federal court or state court, and it was Alabama, somewhere down there, that the judge discovered both the plaintiffs and the defendants' lawyers both had fake sites in their cases, and fined and disqualified both sets of lawyers. So there's a lot of cautions here about using AI in the proper manner. In the legal profession in particular, there's been a lot of wake-up calls that people are not doing what they need to do. But John, it's as big an issue as there is.
So I've got one eye on the clock, and I know we got to get Ken out of here, but we have time probably for one last question, as long as it's relatively quick. Just peering around the room, going once, going twice.
I think it was a yes. It was a yes or no question. The answer was no.
Jim actually has a question.
Oh, okay.
Hi, Jim Hines, University of Michigan.
I know that, Jim, and I'm not going to take your question because you're from the University of Michigan. And I'm just sorry, my wife, if she knew that I answered a question from a guy from the University of Michigan, I wouldn't be able to go home tonight. But
what's this Ohio State, thing
Jim,
we're saying?
Jim, why don't you say you're Mark Prater and you're asking on behalf of Mark Prater, okay?
I'm a friend of Mark Prater's.
Okay, that's good enough. All right, fire away.
So we have enormous deficits right now on budget, and we've got, looming, of course, and Social Security, trust fund issues. And to what extent is the Treasury, and of course, a lot of this is legislative issue, but is the Treasury how is the Treasury thinking about what the future holds for somehow deficit closure on both on and off budget?
Okay, so I can answer that a couple ways. I actually was around for the 97 Act, which many people may not remember. The combination of the tax and spending portions of that not only balanced the budget earlier than actually anticipated. I think we ran a surplus by 98, and by 2001, we paid off $500 billion debt. There's a number of people in this room well, not so much this room, some rooms where they're so young, they don't even know that that ever happened, okay? Is there any active discussion like the one that took place in 97 going on, which by the way was bipartisan? It was Clinton was committed, Erskine Bowles was really committed, who was his chief of staff, Robert Rubin somewhat, but he came around at the end, and obviously Newt, Archer, and so on. That discussion's not happening right now. Frankly, I think one of the problems is we can continue to borrow as much money as we want, and there doesn't seem to be any obstacle to it. We have a wake-up call, which was highlighted by the Social Security trustee report that came out this week. The papers made a big deal of it. The deadline is sooner. It's sometime in, I think, 2032 now. Well, that's pretty much where it's been, just for the record. But we have some clear deadlines out there. And Social Security is one of them. Medicare, frankly, is a much bigger problem. It's a bigger problem because the dollars are bigger and it's a more complicated problem. Social Security is actually a relatively easy to understand problem because the moving parts are pretty much fixed. Labor growth, how long people are going to live, things like that, inflation rates, and so on. But yeah, I would say there's an absence of discussion about these issues right now. And I'm not so sure how long the collective the country can hold out. But by the way, you have a professor who's been there now a couple of years, Chris. What's his last name? He came from Ohio State. Yeah, really great guy. So it's one of the reasons I answer the question, because I like him too. Okay.
All right. With that, Ken, I want to thank you for coming. Please join me in thanking Ken.
Oh, thank you.